From Kern Government Television, welcome to this week's Kern County Board of Supervisors meeting. Originating from the County Administrative Center, located at 1115 Truxton Avenue in Bakersfield, California. Grounded in ideas, energy, and innovation, Kern County's vision is to be a driving force for the world's fifth largest economy. And our mission is to exceed expectations of the communities we serve, changing the way they feel about government, those who manage it, and the services it provides. Today's Kern County Board of Supervisors meeting will convene momentarily.
We'll call this meeting to order. We do believe our other supervisors are coming in, Kathy, correct? Okay. But we're just going to go ahead and get started anyway. Appreciate your patience in the crowd. Thank you and welcome to Kern County's special meeting this afternoon, Monday, May 5th, also Cinco de Mayo. So I hope you have more fun later this evening than this afternoon's going to be. So welcome. We met this morning at 9 to convene and then head into closed session and to conduct some interviews for our airport director. I'll get to that in a minute, but now that our gentlemen are here, can we please call the roll?
Supervisor Peters?
Here.
Supervisor Parlier?
Here.
Supervisor Flores?
Here.
Supervisor Couch?
Here.
Supervisor Perez?
Thank you. Here. As I was saying a moment ago, we convened to closed session to conduct some interviews, and so I'm going to ask our county council if there are any actions taken that we need to report on at this time.
Thank you, Madam Chair. This morning we did meet in closed session on item number 1, and there are no reportable actions.
Thank you very much. We're going to move now. We have 2 items this afternoon. Item 2 and item 3, these are departmental requests from the CAO's office. Number 2, we have a response to April 29, 2025, board referral regarding Assembly Bill 1413 Pappen and Assembly Bill 1466 Hart, groundwater adjudication. And the direction here is to discuss and provide direction. I understand our CAO's team is teed up and ready to go. The floor is yours.
Thank you, Madam Chair, and members of the board. At the board meeting last week, Supervisor Peters made a referral approved by your board to have staff bring back at the next board meeting a discussion on letters of support related to 2 pieces of legislation, AB 1413 and AB 1466. This special meeting was already on the board's calendar weeks ago for another item. As the supervisor indicated, there was urgency to this request. The item has been added to your today's agenda. These bills just passed the Judiciary Committee and are now in the Appropriations Committee, waiting to be scheduled for a hearing. During this critical time of the process, the county may weigh in on its support or opposition for the record. I would now like to turn it over to Thomas Brown, Chief Legislative Affairs Officer, who will provide a brief overview of the bill information, and then I believe Supervisor Peters has a presentation as well.
Good afternoon, Madam Chair and members of the board. As our CAO previously stated, today's item is in response to a referral by Supervisor Peters asking the board to consider supporting 2 state bills, AB 1413 by Assemblymember Pappen and AB 1466 by Assemblymember Hart. Both bills deal with groundwater adjudication and how it fits within the framework of the Sustainable Groundwater Management Act, or SGMA. Jumping right in, AB 1413 is a bill that claims to make California's groundwater management more efficient and less expensive. It says that if a local water agency has already created a valid plan showing how much groundwater can safely be used each year, called the sustainable yield, then courts can't ignore that number later in the lawsuit over water rights. The goal is to stop people from using court cases to get around the limits set in these plans, which can delay efforts to implement SGMA. The bill seeks to ensure that groundwater plans are respected in legal disputes to save time, money, and help protect California's water resources. Proponents of the bill argue that GSPs are developed using technical data reviewed by the Department of Water Resources and often involve public input. This suggests they are credible starting points for determining sustainable yield. If a GSP has already gone through a public process and potential judicial validation, Forcing courts to relitigate its sustainable yield slows down groundwater sustainability efforts. The bill reinforces the idea that SGMA, not prolonged litigation, should be the primary framework for managing groundwater, which is consistent with the legislature's original intent in 2014. Some of the notable registered supporters of the bill include the City of Ridgecrest and the Indian Wells Valley Groundwater Authority. Opponents of the bill argue that not all stakeholders may have had the opportunity or awareness to challenge a GSP during its development or validation window. Locking in a yield without allowing full judicial review can be unfair, especially for those with significant water rights. Under the bill, courts reviewing GSPs and validation actions would be confined to the administrative record, which would limit cross-examination or introduction of external evidence, which adjudications allow. Opponents also argue that SGMA does not and was never meant to allocate or define water rights, and that courts have the constitutional role of determining rights, not agencies. This bill, therefore, would blur that boundary. Some of the notable registered opponents of the bill, and it's important to note that they are opposed unless the bill is amended, include the Indian Wells Valley Economic Development Corporation, the Indian Wells Valley Water District, Ridgecrest Area Association of Realtors, and Searles Valley Minerals. Please note that the California Association of Realtors is outright opposed to the bill. Moving on to AB 1466, this bill seeks to clarify how courts should review actions taken by groundwater sustainability agencies, or GSAs, during comprehensive groundwater adjudications. It would require courts to apply the substantial evidence standard when reviewing approved groundwater sustainability plans or other GSA actions in adjudications. In layman's terms, the substantial evidence standard means that there's enough relevant proof to support a conclusion. It's not about proving something beyond a shadow of a doubt, but rather having evidence that a reasonable person would find convincing. The bill would also require courts to request a technical report from the GSA regarding groundwater use by small pumpers who are not parties to the adjudication. Proponents of the bill argue that it will ensure GSA decisions are reviewed under the substantial evidence standard in adjudications, as in other legal contexts, preventing conflicting outcomes. Proponents assert that the bill would help represent small farmers and rural residents who cannot afford to actively participate in court by providing courts with water data on their behalf. Lastly, proponents state the bill encourages recognition of locally developed, DWR-approved GSPs and limits large water users from seeking more favorable outcomes in court. Some of the notable registered supporters of the bill include the City of Ridgecrest and the Indian Wells Valley Groundwater Authority. Opponents of the bill argue that it seeks to address a problem that doesn't exist, since judicial review of GSA actions already uses the substantial evidence standard during proceedings. Opponents contend the bill inappropriately tasks GSAs with quasi-advocacy roles, like generating water use reports on behalf of non-parties, which is beyond their statutory authority. Lastly, opponents state that adjudications are about determining rights, not validating GSA decisions. So merging the two processes could create confusion and actually expand opportunities for more litigation. Some of the notable registered opponents of the bill, unless it's amended, include the Indian Wells Valley Water District and Searles Valley Minerals. In summary, AB 1413 and AB 1466 both aim to influence how groundwater adjudications interact with locally developed groundwater sustainability plans under SGMA. The bills would make wholesale changes that impact groundwater adjudications throughout the state of California. As requested in the referral, 2 draft letters of support for AB 1413 and AB 1466 have been included in the board packet for your consideration. The recommended action is for your board to discuss the proposed legislation and provide direction regarding adoption of a formal position by the county. This concludes staff's prepared comments. We're available to answer any questions you may have.
Thank you for that excellent, thorough presentation. What are the amendments that were proposed? You said groups were opposed unless amended. Can you share those?
Madam Chair, I can. I have some documents that were forwarded by our lobbyists. They were in the record for the last hearing. So for 1413, and this is a very dumbed down version of the amendments. I beg your pardon because I'm not a lawyer, but So the updates, the amendments proposed updates to update terms like safe yield, sustainable yield, and undesirable results to match state standards. They also say the courts must decide how much groundwater can safely be used before dividing it up. They can use the numbers from state-approved plans or analyze their own if needed. The courts must consider whether local plans are based on solid science and community input. If someone wants to challenge a plan's numbers, they must show evidence. Any long-term water management plans from courts must allow the same rules as formal judgments. Courts can't approve plans that undermine sustainable water use. Courts can revise decisions if new facts come up or if changes are needed to meet sustainability goals. A judge's approval of a plan doesn't mean the state must accept it, and final rulings must support California's groundwater law and goals. So those were the proposed amends for 1413 and for 1466. The courts would decide early in a case whether very small water users, those using 5 acre-feet or less per year, can be officially left out of the lawsuit as long as they stay under that limit. Small users who aren't exempt could submit basic info about their water use. Unless someone proves that info is wrong, the court would accept it. A simple form would be created to make this easier. And lastly, farmers would need to say how many acres they irrigate and what crops they grow, so courts can check if their water use claims make sense.
Thank you. Appreciate that.
So those are, just to clarify, those are suggested potential amendments. They've not been, there's nothing formal.
It sounds like some groups without those amendments can't support it. So I'm just curious what the nature of the amendments were. They're very significant, so I can see why there's some challenges or problems there. But thank you for that really excellent presentation. Would it be appropriate to move to Supervisor Peters for his presentation at this time?
Madam Chair, yeah, that would be the next step, I believe.
Okay, very good. Thomas, I'm sure we have more questions for you. Thank you for your excellent presentation. Supervisor Peters, the floor is yours.
Thank you, Madam Chair. Thomas, if you could go to the next slide. Oh, there we go, perfect, thank you. So AB 1413 and 1466 simply close the loopholes on established process that makes SGMA and groundwater adjudications work together. They maintain the ability to adjudicate, but also maintain local control and input developing groundwater sustainability plans. Current law incentivizes parties to engage in costly, pay-to-play groundwater adjudication processes. As supervisors, I don't believe that we should be picking winners and losers in groundwater adjudications. Current law should not allow big farmers to take away rights of smaller farmers, our local water agencies, the military, or anyone else, because they can afford to pay for adjudications. We shouldn't be moving decisions on water by a local Kern County agency to a courtroom in Orange County, which is outside of the public process and outside of the public view. Could you go to the next slide? In an adjudication, local water rates go up to allow local agencies to defend its water rights needs. In the Indian Wells Valley, water rates have gone up to cover nearly $5 million in litigation costs. That's not to spend on deferred maintenance of their system or create a redundant supply. That's money given to attorneys to litigate against a plan that they publicly participated in, voted for, and now want to cost shift the expense of water sustainability to other parties. What is even crazier is that their plan, if they lose water rights in the adjudication that they initiated, is to go buy the now very expensive groundwater from other parties. Their hope is they can take water from the Navy and then make the Navy pay for that sustainability. But their ratepayers are paying heavy costs for that. Our county and our cities have planning authority. We should not lose the ability for local agencies to control the planning process because someone has decided to take it from us in an adjudication because they want to defer or get out of water sustainability costs. Just because they can continue to mine groundwater during the adjudication. You can go to the next slide. As a county, we should be focused on water supply and sustainability, not just for special interested parties that have money to remove our planning authority and relocate it to a courtroom. If you oppose, I'm going to do my best to sum these up, but if you oppose AB 1466, you're opposing the ability of courts to fulfill its obligation under current law. Current law says that a court must consider the rights of small farmers and disadvantaged communities in groundwater adjudication. But a loophole in the law allows litigants in an adjudication to prevent the court from hearing evidence to support that required consideration. These litigants say if you don't show up in court and pay an attorney, we get your water rights. If you oppose AB 1413, you're okay with the county and our city's losing its planning authority. You're okay with throwing out a local process that creates a sustainability plan and moving it to a courtroom outside of the county. Nothing in this bill determines property rights or water rights. It simply closes a loophole in the process that takes away our local authority to build sustainability for groundwater. Special interests don't want to pay their share of those sustainability costs. They want to continue to mine the groundwater and kick the can down the road. And when I said in a previous paragraph about litigants saying if you don't show up for court and pay an attorney, we get your groundwater right. People have pushed back that that's not the intent, but I'd like to ask our clerk, I think you have a video that I wanted to see if you could cue up.
Yes, just a moment.
Thank you. Just for some background, this is from a testimony in front of the Senate Natural Resources Committee.
So thank you very much for your attendance today, and perhaps you can give us an overview of groundwater disputes and how they affect how it has been affecting the Antelope Valley adjudication, and give us a case study of what are the challenges. I did read the Daily Journal brief article. Sounds like a nightmare, but I'm sure it's a...
Well, I'm afraid it is a bit of a nightmare, but you're very familiar with groundwater law, Senator. Thank you very much for the opportunity to be here today and talk about the Antelope Valley adjudication, which is an adjudication that covers about 1,300 square miles and involves over 75,000 parties. I should note initially, obviously I am in private practice with Best Best and Krieger. I'm not here on behalf of any client today. The views I'm expressing are my own, based primarily on my several decades now of experience in the Mojave groundwater adjudication, Santa Maria adjudication, and the last 15 years in Antelope Valley. A couple of preliminary observations. As you know, prior to this year, the law of California groundwater was pretty much pump until a judge tells you not to. And generally, the only way to limit pumping in a groundwater basin was to sue everyone, have an adjudication, which is simply litigation that involves everyone who has a claim to water in a groundwater basin, and get a resolution of that case. I think there are two things to keep in mind as I go through my testimony. The first is that one reason adjudications take so long is that there are parties that benefit from the status quo, and that at the end of an adjudication, there will be certainty and management. As Justice Roby indicated, the court will generally have continuing jurisdiction, there'll be a water master, there'll be management. And generally that management has been pretty successful over the past several, probably half century now that we've really had adjudication management in place. But because that means if the basin's in overdraft, the parties are either going to have to reduce pumping or pay more for water. For some parties, it's a better deal, frankly, to pay attorneys to delay that resolution, because although attorneys aren't cheap, water is even less cheap. And often it's cheaper to pay people in my profession to delay things than to get to that resolution.
So that's a clip right from the horse's mouth that illustrates some of my concerns. But with your indulgence, Madam Chair, I'd like to ask Mr. Kyle Burchard to come up and just explain a little bit more about the legal implications of these bills and just some preliminary background information.
Thank you, Supervisor. Hello, good afternoon.
Good afternoon.
Could you repeat your name? I didn't catch it.
Kyle Brochard. I'm the litigation counsel for the Indian Wells Valley Groundwater Authority.
Thank you.
Just as a little history, SGMA, which was adopted in 2014 with the goal of managing the overdrafted basins we have here in California. The adjudication statutes were then amended and adopted in 2015 with the express intent not to interfere with SGMA. Everybody said that, and they were very clear. Adjudications are not supposed to interfere with the implementation of SGMA and the management of these basins. Since the adoption of SGMA, through mostly grants from the Department of Water Resources, citizens in California have spent over $500 million adopting groundwater sustainability plans. What you do in these plans is, with required public input and using the best data and science available, these groundwater sustainability agencies have to first define what are going to be undesirable results for the community, what we're not going to accept, and then they have to determine the sustainable yield. What is the maximum amount of water that can be pulled out of the basin without causing those undesirable results? That is what has occurred over the last 10 years. These GSPs have been adopted. They get submitted to the Department of Water Resources, who reviews them. They either approve them, they send them back as incomplete, or they say that this isn't good enough. We're going to send you to the State Water Resource Control Board, and they're going to try and manage your project. When a GSP is adopted, there is already a process available to challenge that. Just like any other action of governmental agency, citizens can file lawsuits to challenge a groundwater sustainability plan, just like zoning ordinances, just like CEQA documents. This is already available. That's what's called the validation process. That's the process, not the name of a cause of action, and it's specifically laid out in the statutes. We use it in a lot of bonding cases also. It's designed to give notice to everybody who could potentially be affected that this action is going to be filed, and that it then allows the public agency to rely on those decisions in making decisions going on in the future. That's already the case. In Indian Wells, validation actions have been filed against the groundwater sustainability plan there. If they're successful, we'll have to make changes, or those changes can be made in the adjudication. That's already the law. What's happening in these adjudications is that the courts are not following through with that validation procedure. They're just kind of ignoring it, and they're saying, well, we're not going to do that. We're just going to do what we're going to do in the adjudication, and we're going to ignore what the GSAs have been doing, while at the same time, these GSAs are trying to continue to manage these basins, and it's causing a lot of confusion. And the courts in these adjudications have said in court, the law is not clear. I know I'm not supposed to interfere with the GSPs, but I don't really know what I'm supposed to do. As a result, we've gone to some legislatures, and the legislature is now, Assemblymember Pappen has proposed a bill that clarifies what it is the courts are supposed to be doing, what the process is supposed to be. If you don't like the undesirable results as they're defined in the GSP, if you don't like the sustainable yield as it's defined in the GSP, that's the process. The validation action is the process in which you challenge that. That's how you determine the size of the pie. And you can still do your adjudication to determine how that pie is divided up. What this bill does is it ensures that the money spent in the GSP process is not wasted, which is also already supposed to be the law. There's already a provision of the Water Code that says adjudications are supposed to be managed in a way that doesn't interfere with the implementation of a GSP and avoids the redundancy and unnecessary costs in developing technical information. That is the sustainable yield that we're talking about. So this is already supposed to be happening. This bill clarifies the courts so they know exactly the procedure they're supposed to follow. It ensures that the community input that went into the GSP is given credence in the adjudication, and that those people's rights can be represented. Courts can then move on right to adjudicating the water rights phase, and this bill also provides a mechanism to allow the courts to receive evidence of those people who can't afford to be there, which is also a problem we're having. In Indian Wells, we tried to get the court to appoint class counsel to some of the people who couldn't afford to be there, the small ag pumpers and the shallow well owners, and the court said no. We asked him if he could refer the matter to the State Water Resource Control Board so they could develop the evidence so that he could consider it in the management actions, and again, he said no. So in that case, you're gonna have a small number of well-financed people putting on evidence that supports their interests, regardless of how that will affect some of the smaller individuals.
Thank you, Mr. Burchard. Are there any questions before I finish up?
Okay.
And if I could just, I'm sorry,
Sure.
one more thing. I hear a lot of talk about the number being locked in and that you can't challenge it. Sigma has a process. The GAs are supposed to submit reports every year, and every 5 years there's a statute that already requires them to periodically evaluate the GSP and assess changing conditions. So there is already a process for people to present new evidence and new data to the GAs, which they are required to consider and to review. And if that's not happening, that's a different lawsuit that you can file to make them analyze the basin, and assess changing conditions.
Absolutely, thank you, I appreciate it. So, I'm almost wrapped up. Oh, I'm good, thank you. I just want to, I know that there's a lot of strong opinions on both sides, but I just want to, reiterate the obvious that we're not deciding whether or not this bill becomes law today. We're merely taking a position on whether or not we support it. Judging by some of the outreach I've had, I'm glad that so many people think that we have the ability to make or break law in Sacramento, but that has not been my experience since I've been on the board. They generally don't listen to what Kern County has to say, unfortunately. But my interest in these bills begins and ends with one question, and that's, does this benefit my constituents? I believe wholeheartedly that the answer is yes, but I would welcome any perspective or chance to hear from anyone that disagrees. I know there are some members of the public that have come out from Ridgecrest that are directly impacted by this, that are going to speak to these bills as we move forward. But I'll wrap it up there and hand it back over to you.
Supervisor Peters, thank you. Thomas, do you want to add anything before we go to the public?
No, ma'am, and in fact, if you have follow-up questions, I would probably defer to county council.
Understood. Thank you. At this point, okay, I'll probably be talking about the law. Very good. Okay, so this is the opportunity for you, members of this community who are leaders, thought leaders, who know these supervisors and know what kind of information I think is effective and helpful to help us be a reasonably informed body. As leaders, your perspective is very important, and we are here to listen to you. I want you to know I have an open heart and an open mind, and my hope is that we reach some consensus and that we hear all the information respectfully and civilly and do what's right for Kern County. I really appreciate you guys being here. We're happy to hear from you, so please come on down. If some of you want to move and maybe sit in the front, that may make us move the meeting on a little sooner, or a little quicker rather, but please don't be shy. We disagree about things all the time in here. Just ask Supervisor Couch. We know how to disagree civilly, and so it's okay. Please come down, give us your heart, give us your passion, help us make the best informed decision for Kern County. Oh, I see a dear friend. Hello and good afternoon.
Good afternoon. Chair Perez, members of the County Board of Supervisors. My name is Scott Heyman. I'm a Ridgecrest City Council member and chairman of the Indian Wells Valley Groundwater Authority. So as a city council member, I've held a seat on the Groundwater Authority for the past 7 years, which also happens to make for the longest serving elected official on that board. In short, I've seen it all when it comes to groundwater or achieving groundwater sustainability. So I have a question I'm going to ask you. Do you want everyone in Kern County to go through what we are going through? Kern County has two adjudications, the Indian Wells Valley and the Cuyama Basin. They are costing millions and millions of dollars. The planning authority of the city and the county are being stopped by those with financial ability to take water sustainability away from us locally and place it in the hands of a judge in Orange County. Current law incentivizes costly groundwater adjudications. It is costing Ridgecrest residents nearly $400 a year to support the litigation cost the retail water district filed to attempt to cost shift the sustainability measures to the U.S. Navy. What is ridiculous is they have filed litigation and may actually lose water rights to wealthier parties. The retail water district is seeking to take the water rights of the single largest employer in the city, jeopardizing our future, and set sustainability at a limit that literally stops economic growth of the city. Also, it can kick the can down the road. They seek no redundancies in our system and no ability to connect to the outside world. If an emergency happened that cut water supplies, they are not prepared and are home to one of the most critical defense installations in the United States. They have deferred $100 million in maintenance to their water system to pay for litigation that they initiated. AB 1413 and AB 1466 stops the incentive to enter into a costly adjudication. It stops the ability of the wealthy to take the water rights from the disadvantaged communities and small households. It favors a local process rather than a process that costs us millions to defend in Orange County. It sets a statute of limitations and allows all of us the ability to plan for sustainability. Everyone gets their day in court to divide water rights. That's their right. But it doesn't allow those with the most money or those willing to raise your water rates to get to bypass the process that the law has already established. AB 1413 and 1466 stops incentivizing bad behavior. I urge you not to go down that path and to correct the law and support AB 1466 and AB 1413. I thank you for your time in this matter.
Excuse me. Thank you, sir. Good afternoon.
Hello. Thank you, Supervisors, for allowing me to share my thoughts as you deliberate Assembly Bills 1413 and 1466. I'm Dr. Baines. I'm the Assemblywoman for 8035. I saw these bills in the Assembly Water Committee last month, and I can tell you that there is a very good reason why every lawmaker from the Valley voted against them. These bills are being pitched as a relatively mundane proposal that will ensure SGMA is implemented the way the legislature always intended it to be. I sympathize with the proponent's stated intention of streamlining groundwater management and protecting small farmers who can't afford expensive legal representation. Those are admirable goals, but the problem is you don't protect the legal rights of some by taking away the rights of others. These bills represent a fundamental shift in how water rights are determined in court, and they do it by forcing judges to be less objective and less informed. AB 1413 would outright force the courts to accept a GSA sustainable yield determination. That court would be barred from checking their work or conducting an independent review. The GSA says the number is X. The court has to accept that it can't be higher than X. No questions are asked. Does that strike anyone as a little bit problematic? Because last time I checked, determining water rights was the constitutional role of the courts, not bureaucrats. Water in California isn't just water, it's property. When we talk about water rights, we're talking about property rights that in many cases have existed in the Valley for generations. If AB 1413 becomes law, we're saying that an unelected local agency can steal your property and the courts are barred from even asking why. Now let's talk about AB 1466. This bill confuses a process of challenging a groundwater sustainability plan with the process of conducting a groundwater adjudication. It places substantial new responsibilities on groundwater agency with limited staff and few resources, pulling them away from the responsibility of implementing SGMA. Let me be very clear. I'm not against managing groundwater sustainability. But the irony here is stunning. Despite significant concerns when the law was passed, SGMA has been mostly working. Out of 93 groundwater sustainability plans developed statewide, 86 have been approved. Only 5 basins have gone to adjudication. The system isn't broken, yet these bills are looking to change the rules that got us this far, and they create far bigger problems than they solve. AB 1413 and AB 1466 do not strengthen sustainability. What they do is upset the careful balance that has worked in nearly every basin out there. Look, there are better ways forward. The opponents of this bill have tried to engage in productive conversations with the authors and have offered reasonable amendments that would protect small water users and property rights without undermining due process. In their current form, these bills do not protect vulnerable communities or achieve sustainability. They are a water grab wrapped up in a judge's robes. I urge this board not only to reject supporting these bills, I urge you to formally oppose them so we can work together to stop Sacramento from following our fields, gutting generational water rights, and putting farmers and farm workers out of jobs. Thank you very much.
Thank you. Who's next? Good afternoon, welcome.
Hi, good afternoon, Chair Perez and members of the board. Thanks so much for being here. Melissa Frank with the wonderful company. Nice to see you all. I would just say there are certainly challenges with the SGMA law and SGMA implementation. We've seen that throughout the state. And the groundwater adjudication process is not perfect. So I will accept that there are lots of problems with the current situation, but I don't think these bills are the solution or a solution to make SGMA work better or to make groundwater adjudications better. I think there might be situations where these bills would help, but the problem is this would fundamentally change the law and could take away the authority to adjudicate groundwater rights from the courts, which is always where they have been and where the SGMA statute says they should stay. So while there are ways I think we should all be thinking about how to make SGMA work better and how to make groundwater adjudications more efficient and more fair for all participants, these bills are not the solution. So thanks so much for your time.
Thank you. Who's next? I don't see shy people in this crowd, so don't pretend now.
Good afternoon, Chair and members of the board. My name is Rachel Nettleton. I'm the Executive Director with the Kern County Farm Bureau, and alongside me is our first Vice President, Alex Dominguez. I'm here today on behalf of the hundreds of farmers and ranchers in Kern County that we represent to express our opposition, unless amended, to AB 1413 and AB 1466. Two groundwater-related bills that threaten the rights of water users in Kern County and across the state. These bills are being promoted as tools to streamline the Sustainable Groundwater Management Act and the adjudication process, but in reality, they undermine due process, weaken judicial oversight, and put our local water users at risk. AB 1413 would limit the ability of courts to review groundwater sustainability plans. It allows these plans, which may be based on flawed or incomplete data, to be treated as final with no opportunity for landowners or water users to challenge them in court. This could lead to unfair outcomes and long-term harm to water rights across Kern County. As for AB 1466, shifts the burden of proof entirely onto those challenging groundwater agency decisions. It would make technical reports from GSAs automatically count as strong evidence in court even before they are tested for accuracy. That means smaller growers and family farms could be left without a fair way to challenge decisions that affect their livelihoods. Together, these bills limit access to fair legal processes and tip the balance of power too far away from the people who rely on groundwater every day. We respectfully urge the board not to support AB 1413 and AB 1466 unless they are amended to protect due process, fairness, and the rights of Kern County water users. Thank you for your time and your continued support of agriculture.
Thank you, ma'am.
Good afternoon, board. My name is Dan Clifford. I am Vice President of Bolthouse Properties. We don't grow the carrots, but we've got the ground where the carrots are grown. And as a result of that, bills that address water issues such as this get our attention. I am intimately familiar with SGMA. We have been involved in a comprehensive groundwater adjudication in Cuyama for the last almost 4 years. As a result of that, I have been on the front lines of this adjudication. I can tell you that the two bills that are currently being contemplated are troubling, to say the least. Dr. Bain's comments, I think, hit the nail right on the head. The greatest issue in our mind with the bills as currently crafted is the impact on due process. When Sigma was passed in 2014, part of the grand bargain was that it considered the possibility that groundwater adjudications would be used in order to establish and ferret out water rights. That is a judicial function, and that was cooked into Sigma in 2014. And as a result of that, parties such as Bolthouse Properties and others, other farming interests, have availed themselves to that right afforded to them in Sigma. And now, this loophole that is being discussed is apparently trying to be closed. It's not a loophole. It was always there. It was there in 2014, and it was the reason why Sigma was, or one of the reasons why Sigma was able to be passed. So I would ask that this board not only not support, but come straight out and oppose the bills as crafted. They are damaging to all groundwater users, whether or not they're farming interests, industrial users, or municipalities. It is not a good bill. It should not be supported by Kern County. So what I would ask that the board give a full-throated opposition to those bills as drafted, and I appreciate it, and thank you very much for the opportunity to address you.
Thank you, sir. Who's next? Good afternoon and welcome.
Thank you. Good afternoon, Chair Perez and other members. My name is Matt Vickery. I'm Vice President of Natural Resources for Grimway Farms. I'm here today to express our concern as it relates to the county taking a position on Assembly Bills 1413 and 1466. We share the bill author's goal in seeing Sigma implemented successfully. However, the precedent these bills would set is deeply problematic and would, among other things, deprive groundwater right holders of due process and judicial review. As the nation's top agriculture producing county, your support, opposition, or neutral position on these bills would have far-reaching implications. So in conjunction with Western Growers, California Farm Bureau, Cal Chamber, and many others here, I'd ask that you consider a position of opposition unless amended to these bills. Thank you for your time.
Thank you, sir. Good afternoon and welcome.
Thank you. Thank you, members of the board. I'm Dennis Cruz. I am president of Cerros Valley Minerals. We're a mining company in Trona, California. We also provide water to the residents, the 1,800 residents of Trona, California. We are one of the largest and highest paying employers in the region. We have a $675 million annual economic impact to the region. We're asking that you do not support AB 1413 and AB 1466. While these bills are being promoted as tools to streamline groundwater management, they pose serious risk to our water rights, due process, and long-term economic stability of this community. We support Sigma. We want to balance the water. We know that's critical, and we're willing to make the investments to do so. However, what makes us different? AB 1413 would require courts to treat the sustainable yield number in groundwater sustainability plans as binding, even if the underlying data has not been made publicly available and is flawed. Indeed, after years of Public Records Act requests and litigation, only 2 weeks ago did the GA finally release a portion of their study that they used to develop their GSP. This undermines water rights, limits judicial review, and could permanently lock in inaccurate groundwater assumptions that hurt legitimate users like us. Only a handful of basins are in adjudication now, as noted earlier. This bill overreaches and creates litigation risks for many others. AB 1466 treats government agency reports as strong evidence, which can be hard to refute even if they're wrong. This stacks the process against smaller or less resource stakeholders. We respectfully ask that you do not support AB 1413 and AB 1466. In fact, we will urge you to oppose these bad bills and stand with nearly the entire business and ag community in the Central Valley and the state of California who oppose these bills and support fair and balanced water policy. We're so hopeful we can solve this as a community. We want to continue our long partnership with our local leaders. That's one of the reasons why we've been mining for 152 years continuously. Thank you.
Thank you, sir. Who's next? Welcome and good afternoon.
Good afternoon. My name is David Buffington. I'm General Counsel for New Carrot Farms, better known as Bolthouse Fresh Foods. I'm not going to add much to what all these citizens and people before me have said, except to say there's a reason that all these citizens and prominent businesses from Grimway to Bolt House to the Small Farmers Association, or the Realtors Association, to Wonderful Company, are all urging you to oppose these bills. 10 years ago, everyone here, I think, recognizes that water adjudication is a thorny issue. We all get it. So 10 years ago, we came up with a process. There would be a groundwater plan proposed. Everyone could take a look at it, and they could take it to an independent arbiter, the court, to figure out a fair solution for all. Everyone has that right. These bills essentially gut the independent process. It takes that out of play completely, and it's a process, while some have said not perfect, it's working. It's working. So my only point is, if it ain't broke, don't fix it.
Thank you, sir. Good afternoon and welcome.
Madam Chair, thank you. Thank you for hearing me. Supervisors. Everything's pretty kind here at this board meeting. So I appreciate the way everybody has approached the podium. And there was a lot said in the initial presentation. Supervisor Peters, I appreciate your presentation. So I'm Kyle Blades, City Council, City of Ridgecrest. And contrary to the folks that were just up here, I am urging your support. I'm adamantly urging your support. So our community is facing endless legal battles, and I think that's happening across the state. It's straining people's resources, it's straining their bank accounts. The way I see it, AB 1413 and AB 1466 is closing loopholes that are currently being exploited in order to delay SGMA. We need to ensure that groundwater sustainability plans are implemented as they're intended by respecting public input, scientific expertise, and years of invested public funds. These bills, again, the way I interpret them, they streamline adjudication, harmonize SGMA, and reduce duplicative litigation and promote fairness for all water users. I've heard the opponents claim that these bills interfere with water rights or impose over-regulation, but what I've seen in reality, existing adjudications favor well-funded parties, sidelining small users. These bills do not overturn legitimate rights. They guarantee adjudications are efficient, equitable, and consistent with validated GSPs. Courts have recognized that the problem is not excessive regulation, but a lack of clear, consistent legal framework. Without this clarity, uncertainty persists, investment stall, and sustainable solutions are obstructed. These bills remove ambiguity by deferring to scientific expertise and the public groundwater sustainability planning process. The Indian Wells Valley Groundwater Authority has worked diligently towards sustainability. Lots of public input and a lot of money has went into working on the GSP. Supporting AB 1413 and AB 1466 is essential to uphold fair, science-based groundwater management and protect our basin's future. I respectfully urge your support.
Thank you, Councilman.
Thank you.
Good afternoon and welcome.
Thank you, Madam Chair, members of the board. My name is Isaac St. Lawrence. I'm here today on behalf of Henry Miller Water District and Buena Vista Water Storage District, both GSAs here on the Valley floor. To give a little bit of a different perspective from some of the GSAs here on the Valley floor regarding these bills. As mentioned, both Henry Miller and Buena Vista are GSAs managing their portion of the basin, the Kern County sub-basin here. Their board members would love to be here today, but they are in a very important coordination committee meeting where all the local GSA members are currently right now, so their apologies. We, on behalf of Henry Miller and Buena Vista, strongly urge you to not support AB 1413 and AB 1466. SGMA requires these GSAs to develop a groundwater sustainability plan. These plans are a work in progress, a living, breathing document that is limited by our data and information that we have as it relates to groundwater. Both Henry Miller and Buena Vista acknowledge this. Most of the times when we're establishing a safe field, it is a best guess estimate. And to the extent that we can get greater information and data, that's great. But we understand that this is not locked in stone, whatever the GSA says. It's what we can work with now, oftentimes. Because of that, that is why we find AB 1413 so dangerous. it essentially makes the GSA the king. When the GSA says, this is what your safe yield is, this is the size of your pie, well, that's what you're stuck with, and the court can increase that. No matter what that number may really be, the court can't even consider evidence contrary. New scientific evidence, can't consider it. Cross-examine a witness, can't consider it. GSA said sustainable yield is X, it's X. We can't go above X. Frankly, Buena Vista GSA, Henry Miller GSA don't want to be king. They recognize that they represent their landowners. Their landowners should have every right to challenge a sustainable yield, the size of the pie, before the GSA and before the courts if that's necessary. I've heard concern that this law is needed because larger farmers can take advantage of smaller farmers in adjudication. In reality, this law worsens the problem. Larger farmers are the ones who sit on the boards of the GSA. I had a farmer told me that he's on the board of a GSA where their farm owns over 50% of the land in that GSA. They could set the sustainable yield in such a way that hurts all the other farmers, and that couldn't even be challenged in court. You're taking away land, this bill takes away landowners' due process rights and that alternative to seek a remedy in the court. So for that reason, on behalf of, well, and let me get to AB 1466, which legally is just a difficult one to read. It really convolutes the burden of proof and tries to solve a problem that does not exist. But the other, a more concerning thing as it relates to the GSAs is it creates this burden on a GSA to create a technical report to detail uses of individuals who have not appeared in that action, in the adjudication. GSA's got enough burdens and responsibilities on their hand in managing a basin, and I know Henry Miller and Buena Vista do not want an additional one. So both Henry Miller and Buena Vista GSA strongly urge you to not support these bills, and in fact to oppose these bills. They hurt Kern County farmers, and they hurt groundwater sustainability agencies here on the valley floor. Thank you for your time.
Thank you. Hello, welcome, good afternoon.
Good afternoon. Steve Jackson on behalf of Diamond Farming Company.
I'm sorry, who? On behalf of?
Diamond Farming Company.
Thank you.
I just want to give you a little bit different perspective. I have served in, I think, 4 GSAs. I've been involved in the process for about 7 years now, and across 5 different subbasins. And this is a messy process. We are tasked with trying to divide up a very small pie, and whenever you're involved in this process, it's as some have spoke before, it's never some of these estimates, or sometimes the sustainable yield is the best estimate we can get to. But I think I just want to speak to the fact that this legislation, I think, is misguided. I think it really needs to go back. When I think about SGMA, when it was passed back in 2014, there was truly a grand bargain to get this legislation passed. And one of these things, key things, was access to the court. There's no doubt we've overdrafted. I work in areas, all types of landowners. We're going to have to get this right. But I urge the board, you're here not as a legislative body. You're actually being asked to support legislation that I would strongly urge you to oppose, at the very minimum, to ask for an amendment to be done. So I just, again, this we got to get it right. It's going to be an expensive, long process. And I just ask the board to oppose, or at the very minimum, ask for some amendments.
Can I ask you a question? You have such great expertise. For the record,
I don't know if I have great expertise.
Yeah,
I've seen a lot. I'll put it that way.
I don't know you, and I have not spoken to you before today. I just want to set that for the record. But what is your best sense about, when, apart from this, let's say the legislation fails, regardless of what happens today, what do you think what is the time frame by which the public or members that are impacted by this process? There aren't my constituents necessarily, so I can't speak for them. But what is your sense about timeline?
Timeline to address those who are being impacted by the.
No, that a process. Let's say the legislation fails and the original intent, as you stated, moves
it's
forward.
interesting you say that. I think my concern is we have a couple million acres in our potential probation, here in the Central Valley. It is again, this is going to take years to sort out. We didn't get here overnight. We have been overdrafting for decades. So to get us back to sustainability is going to take some real effort. It's going to cost. Let's face it. This Kern County is the largest farm producing county in the state, in the nation, right?
And the nation.
And we're
3,069
faced. I
counties.
work with landowners. We're talking billions of dollars of lost equity. We're going to talk billions of dollars of lost income. So when I say let's make sure we get it right, we need to go through this process. It's going to be messy. There's going to be difficulties. I know. There's going to be a lot of issues, but I think we just have to keep pressing forward and do the best we can. The GSAs, the boards I've served on, we're trying to do the best job we can, but we're not perfect. So to get there, we're going to need some time. Let's leave the legislation as it is. That's what I would urge the board to, at the very minimum. I don't want to see these bills go forward in their present form.
Thank you, sir.
Okay?
Appreciate
Thank you.
you. Good afternoon.
Good afternoon, members of the board. My name is Jeff Simonetti, and I'm with the Capital Corps Group on behalf of the Indian Wells Valley Groundwater Authority. Appreciate the opportunity to speak with you this afternoon, and I know we've had a lot of speakers, and just want to clear up a couple of misconceptions about the bill and the points that we're trying to achieve here. First, we want to make sure that you recognize that this bill is not taking away due process. The Sustainable Groundwater Management Act had the ability to be appealed and challenged. In fact, many groundwater sustainability plans were appealed and challenged. What we are saying is once those appeal processes move forward and have been exhausted, we shouldn't be allowed to reopen the process of looking at the sustainable yield once all of those challenges have been extinguished. And that's the crux of this bill. Second, it does not stop adjudications from allocating groundwater rights. So once you've established the size of the pie, it is saying that, yes, courts can go out and say who gets what part of the pie. What we are saying is there shouldn't be a duplicative process of going through appeals to determine that size of the pie. Once the Sustainable Groundwater Management Act has been implemented, a groundwater sustainability plan has established that, and those appeals have already taken place. So without this bill, there are two important things. One, it would continue to allow millions of dollars spent in defending groundwater sustainability plans from the process. And that will, again, like we've heard from the city of Ridgecrest, be borne on the backs of local taxpayers. Second, it will hurt small farmers. There's a gentleman who mentioned that small farmers are supportive of this. In fact, the California Alliance of Family Farmers are supportive of this, not opposed to it. So that is an important thing to remember. So again, thank you for your time and appreciate this, and I hope you can support this bill.
Thank you, sir. Welcome. Good afternoon.
Thank you. Good afternoon, supervisors. I am Sarah Rizzardini, immediate past president of the Ridgecrest Area Association of Realtors. Thank you for your time today on this very important topic. Our response to AB 1413 and AB 1466 was emailed to each of you and should be in your packet. Our concern specifically with AB 1413 is that this legislation will prohibit due process. For this reason and others stated in our response, we ask that you consider opposing this bill. As for AB 1466, we are following the California Association of Realtors and taking a watch position on that bill. Thank you.
Thank you. Please come on down to the front if you would like to speak. Can I actually get a show of hands? Who else here is waiting to speak? 1, 2, 3. Oh, okay, we still have a good amount of speakers. Okay. Good afternoon.
Good afternoon, supervisors. My name is David St. Amand, and I'm the president of the Indian Wells Valley Water District. You have a letter from me from the Water District in your packet stating that we oppose this legislation unless amended, so I won't bother reading that to you. Others are covering the legal ramifications more effectively than I could, so I'm not going to go into those details, but I will focus on why we're here today. Of the more than 90 GSPs that are out there, only 5 are in adjudication. One of those is the Groundwater Authority, to which my organization is a member, the Indian Wells Valley Groundwater Authority. The ones that are in adjudication, generally, one is, I think, for a lack of understanding of the hydrology of the area, and the other 4 appear to be for a lack of transparency. And that is why we are here today. The Indian Wells Valley Groundwater Authority has exhausted their options in the courts to ignore recent hydrological data and studies when determining the safe yield for our basin, studies whose conclusions often contradict those of the Groundwater Authority. These Assembly Bills, 1413 specifically, would accomplish that goal, protecting the conclusions of the Groundwater Sustainment Plan, which are apparently indefensible in court, and effectively silencing the voices of opposition. The Indian Wells Valley Water District is committed to supporting the Sustainable Groundwater Management Act and reaching sustainability in our basin. These bills, as originally written, would effectively assign authoritarian powers to the Indian Wells Valley Groundwater Authority, and that is contrary to the spirit of the State Groundwater Management Act. I urge you to either vote to oppose or oppose until amended these Assembly bills. And I thank you for that consideration. Additionally, I'm here, and there have been a large number of accusations made about the groundwater, the Indian Wells Valley Water District, and the latest one of which is that we're $100 million in arrears on maintenance. That is simply just not true, totally inaccurate. We have a well-organized, well-run, financially sound organization which has an excellent credit rating. Our reserves are slightly depleted because we have been dealing with damage from the 2019 magnitude 7.1 earthquake that hit our valley. And our system's in such good repair that there were no leaks on our side of the meters. Most of the leaks took place on the customer's side and were addressed immediately. Since that time, we've had some fractures in our lines that were steel-lined concrete pipes that were likely due to the earthquake, and they're only now manifesting themselves. That is not deferred maintenance, but it is something that must be addressed and is being addressed currently. And if you have any questions for me about any of the other issues, I'd be happy to answer them.
Thank you so much.
Okay, thank you very much.
Appreciate- Oh, I'm sorry, Supervisor Couch has a question.
Yes, sir.
Supervisor?
Thank you. I didn't catch your last name.
David Saint Amand.
How do I spell that?
S-A-I-N-T-A-M-A-N-D.
Thank you. I really asked for
Oh,
our
okay.
clerk down here. I could swear that 2 speakers ago, there was someone from the Indian Wells Groundwater Authority that was speaking in favor of the bills.
That's correct.
You're the president of the authority.
No, I'm the president of the Indian Wells Valley Water District.
Water District. But you're on, are you, or is there a member on the authority?
Our board has a member representative on the Groundwater Authority's board.
So you may not be the specific person to ask, but is there an official position from the Indian Wells Groundwater Authority?
On this legislation?
Yes.
The Indian Wells Valley Groundwater Authority, as they stated earlier, are in favor of these pieces of legislation.
Is it unanimous?
No, it is not. The Water District, which is has one representative on the board, does not agree with that.
Okay, thank you, sir.
All right, thank you.
Excuse me, and that's consistent with your position?
Yes.
Are you aware of any other no votes on that board?
On the board of the Indian Wells Valley Groundwater
Correct.
Authority? I am not aware of any other no votes on that board, no.
Did you get the sense that your person was the sole, the lone soldier?
Yes.
Okay,
That
thank
is, that's a situation that has been the case for a number of years.
Understood.
We don't agree with everything. When we've brought new science to the table, we've been rebuffed, and there have been accusations made about our organization and our motivations. And our organization is dedicated to bringing quality water to our customers as inexpensively as possible. And we've researched a number of other possibilities than those that are being resolutions to the problem that are those being proposed by the GA, and they just will not hear them.
That's very helpful. You know whiskey's for drinking.
And water's for fighting over.
A whole lot.
Yes, ma'am.
Thank you, sir.
Thank you.
Appreciate
Madam
it.
Chair, can I ask you a couple questions?
Oh,
Thank you.
Supervisor Peters.
Yes, of course.
Did the Water District, while it was a member of the Groundwater Authority, vote to approve the current groundwater sustainability plan?
Those would be Director Kaczynski, who did at the time with the understanding that the numbers would be adjustable as new information came in, and that has not proven to be the case.
Okay, just Just curious, and they are reviewable every, as part of the periodic review process that we're legally required to go through.
One particular
There was-
instance,
ex-
where
sorry,
did
just
the?
one second.
Okay, sorry, my apologies.
And then
No problem.
I know that there was something mentioned earlier, not by you, but by another speaker, about issues with not being able to see the model, which unfortunately, although it was available at that time and it was voted on by everybody, including the Water District, has since been classified by the U.S. Navy, which is far above our pay grade. But when was the groundwater, or excuse me, the Water District's model done that you were mentioning?
I will defer that question to our counsel, who has better knowledge of those dates. Jim Worth?
Great question.
Okay, thank you. Those are my only questions.
Thank you so much for being here. And
Good afternoon, Madam Chair, members of the board. Your question again, I'm sorry, Mr.
Your name, sir?
I'm Jim Worth. I'm an attorney for the Indian Wells Valley Water District.
Got it.
Mr. Sanamon just mentioned the data that was presented by the Water District. I was just curious when that was developed.
Which data? We presented the Indian Wells Valley Groundwater Authority with a storage assessment in February of 2024. We gave you our safe yield assessment, and I think it was September of 2024. We gave you a pipeline cost line analysis because the Indian Wells Valley Groundwater Authority didn't do that. I believe that was given to them right around the same time as the safe yield assessment. And the question is, why didn't the GA do a cost-benefit analysis on a $300 million pipeline that they're going to put on the cost of our ratepayers up in Ridgecrest?
Okay, Mr. Worth, there is that information out there that's been developed by the Groundwater Authority, but that's outside of the scope of what we're discussing here right now. And I'm happy to point to those. I was just asking that when that information was given to the board for the benefit of a more transparent discussion. And that was last year after the Water District had filed their adjudication, correct?
That's correct.
Okay, thank you.
May I add some clarification since I'm up here?
Please.
The reason we're here is, I hear about transparency, collaboration. That's not what we have here. In 2020, the Indian Wells Valley Groundwater Authority adopted a groundwater sustainability plan. In that plan, the sustainable yield was 7,650 acre feet. It was not widely recognized as the right answer. However, if the GSP wasn't approved, we were going to go under possibly state probation. So we voted for it with the assurance that it would be a living document, much like Sigma is intended to do. That's why they have a 5-year periodic assessment. And we have not seen the model for that. So they took that 7650 sustainable yield figure, and they applied a 2,031 acre foot tax on the Water District to fund water, a water purchase. And to date, they've collected $14 million from the Water District ratepayers to purchase water supplies for this pipeline that's yet to be built. And we don't have one drop of water secured. And just in terms of trusting, their number in 2020 was 7,650. They had 5 additional years to use all sorts of new data, aerial, electronic, magnetic, and stuff like this. They just came out with their periodic assessment. You know what their sustainable yield number is?
What?
7,650. Not 49, not 51, down to the acre foot. Almost impossible if you talk to anybody that knows geology. I think I'm taking my time unless there's any questions.
If you had to, what's your estimate about a more accurate yield?
Anywhere probably between 11 and 14,000, being an attorney and not a geologist.
And the military's about 9,000, right? Their use?
Their pumping right now is approximately 1,500 acre feet. They've come on paper as saying they have a long-term need of 2,041 acre feet. However, right now, the phase 1 trial on our adjudication is underway, and that is to quantify the Federal Reserve water right, which can only be done by a comprehensive groundwater adjudication.
Okay, so have the military's water upgrades then led to a smaller usage from them? Because that seems a lot smaller than I recall.
Both the Water District and the Navy over the past 10 years have undergone extensive conservation efforts. I've heard one thing that the Navy saved 47% on-base use, so there's been a...
That makes sense. Wow. Thank you so much. Supervisor Peters.
Thank you. Do you know about how much water is being pumped per year out in the Indian Wells Valley groundwater basin currently?
Approximately 20,000 acre feet.
So even with the much increased assumptions made by the water district, we're still almost 50% deficit of what we would need for water.
It's my understanding that the GA has forced Mojave Pistachio out of there, so they won't be pumping water very soon. And if there's any overdraft in the basin, and there probably is, but it's more in the terms of 3,000 acre feet, best estimate. And I would also say, in place of a pipeline, we've got a water treatment plant up there that if we would take that water, treat it, and inject it into the basin, the water, the facilities, everything needed are in that basin, we could get another 2,000 acre feet. But all they want to do is build a pipeline.
Thank you, sir.
You're welcome.
Just as additional clarification, the Indian Wells Valley Water District is a county special district. We are not a for-profit organization. And
You have been so helpful.
thank you.
Thank you for everything. Please come forward. Good afternoon. Welcome.
Good afternoon. My name is Chuck Griffin. Thank you, directors. I am the Indian Wells Valley Water District's representative on the Groundwater Authority Board. So Mr. Couch was asking that question. So that is my role. So I attend the Groundwater Authority meetings. And if you had any questions for me, I'd be glad to answer them.
Well, that was quite a dramatic entry into the
It was pretty good.
conversation.
It was
Wow.
quite the introduction.
Yeah,
I didn't plan on speaking, but
Get up
I
in here.
wanted to answer any questions. I heard some comments, so while I'm here, I want to make clarification to some of those comments. I've heard the comments that the Indian Wells Valley Water District was challenging the Navy. In no way are we challenging the Navy's rights trying to take water from the Navy. That is the very first thing that has to be established in the adjudication is the Navy's rights. We want the Navy there. We support the Navy as a board. All 5 of us are very supportive of the United States Navy and the mission of China Lake. So we want to ensure that. What is frustrating to us as board members are there are other options that we feel are available. Looking at new science that we've spent the money from the ratepayers to do, we have the science that shows that we have an actual larger recharge than what is written in Sigma. And by passing these 2 bills, that eliminates the chance for us ever to prove that. We've presented it to the GA. I've asked at the GA board meetings, could we hear this? It's been looked at. They said they've filed and received, and that's as far as it's ever went. So we would like that data to be looked at. If we sit down one-on-one and negotiate, talk about it, that's what we would like to do. We want to work together. The divisions that has caused our community is terrible. We have friends that aren't friends anymore. It's created problems with businesses. And Ridgecrest is not that type of a community. We are a family community, and that's the way we need to stay. So if you had any questions, I would be glad to answer them. But you asked about a vote on supporting these 2 bills from the Groundwater Authority. I have not heard a motion made to support or not support. I would not have supported if there was a motion made. I do not, just so you're aware, I do not attend the closed session if it involves anything that's legal, because I guess each attorney from both sides has said I shouldn't attend. That would be a violation. So I'm not allowed to go into closed session. So I'm kind of a at-free, non-effective board member, to be perfectly honest with you. That's how I feel most of the time. So
What's your sense about what's at play here? What's your best sense?
I believe that if these 2 bills get passed and if you guys endorse them, that this will essentially eliminate the potential for our community to not have to fund a pipeline that I don't feel is needed. You heard the wastewater treatment. There's water up north. It's not very far from us. It's a lot cheaper to get water from north than it is south. We have Inyo County, who's a member of the Groundwater Authority, who the water district has 1,500 acre feet of water that we currently own in that valley that we could export into our basin, which is in the same county, and that would eliminate a lot of needs, but none of that's looked at. And there's answers there that we don't have to build this pipeline, that we gotta pump water that passed us in 100 miles past, and then we got to come 100 miles back uphill, install 3 or 4 lift stations. It just isn't feasible for our community. We've paid $14 million. I've heard the cost of the ratepayers. It's expensive because we have the ratepayers paying the attorney fees. As a board member, I would rather see my ratepayers spend $5 to $7 million one time to defend something that over a lifetime is going to cost them millions and millions. We've paid $14 million so far to the Groundwater Authority that has went nowhere. And by the time we get a pipeline, that fee's still going to be there, so it's going to go on forever. But if we can come together as a group, the Water District, the Groundwater Authority, the county, the city, and we can make a solution that's local, it will be much more cost effective for the long term for my kids, my grandkids. I was born and raised there. My dad was there. And I've got 6 kids and grandkids there. So I plan on being here a while. So thank you.
Thank you for your knowledge and for being here. Are there any other Supervisor Peters, did you have another question of him?
I just did have one now, not from Mr. Griffin, but I did want to see if we heard some comments about the GSA and in particular, and then some about the aspects of the law in relation to this. And I wanted to see if either Phil Hall or Kyle Burchard might come down and respond to a couple of those points that were made.
Hello again.
Hello.
What would you like me to address? There was a lot.
Yeah, there's a lot to
I can
unpack.
start with, we've heard repeatedly that what these bills would do is that the sustainable yield would be locked in, or that it can't be changed. And again, that is incorrect. That's not the law now. That wouldn't be the law in the future. GAs have an obligation to continually assess new data and assess the conditions of the basin on a 5-year basis. As to the water district, they filed the adjudication in 2021, and the new data that you heard that they said wasn't considered that required the adjudication was from 2024, which is an interesting trick. In September of 2024, they did submit a report that alleged that there was a higher sustainable yield. That report repeatedly referenced an unfinished model. We had asked that the water district provide the model to the GA so they could consider it in our 5-year evaluation. We had even agreed to an early exchange date of the models in the adjudication. In, I believe it was January, 2 weeks before the parties were supposed to exchange the models, the water district's attorneys went into court and told the judge their model was not ready. The same model that was the basis for part of the report in September was not ready and couldn't be exchanged. Those models were just exchanged a couple weeks ago, so we haven't even had a chance to look at it yet. Certainly didn't have a chance to look at the model that they just finished prior to them following the adjudication in 2021.
Understood.
And if there was no adjudication, that information would be considered, it would be discussed, it would be evaluated, and if it required amendments to be made to the plans and the management actions in the GA, that's what the law would require, and I imagine that is what the GA would do. Also, I know there's a lot of other interests that have been here. I would just note for the supervisors that Bolthouse and Grimway are in the Kuyama adjudication. In the Kuyama adjudication, they just stipulated to the sustainable yield number that was in, that is consistent with the groundwater sustainability plan with the GA. So the only thing that was accomplished there was attorneys made a good amount of money. And if you are less well-financed than them, you've now expended some of your resources as that adjudication continues to drag on. All this bill would have done in that case is expedite the process.
Thank you, sir. Next. Welcome. Good afternoon, Mr. Hall.
Good afternoon, board members. As you know, I represent the county's interests on the groundwater GA from a legal perspective. We've been doing this for a decade now. I can give you a lot of past history on that groundwater sustainability agency. But based on what we've just heard, I think we should talk about a few things. The Indian Wells Valley Water District in 2019, when the GSP was developed, was the general counsel, general manager, and board president for the GSA. All of the technical work was done with their support and their hydrologist being involved in it. They approved the plan. They then didn't like the plan when they figured out that they were going to have to pay for imported water. There was a vote unanimous all the way through until June of 2020 when it came time to start paying for the sustainability project. Now, you've heard earlier today about this $100 million. That's not a number we came up with. That's a number we've pulled out of their staff reports in 2021. September 2021, Indian Wells Valley Water District was asked to lower the impacts on ratepayers by bonding when rates were historic lows to buy the water we needed for the import project. They decided not to do so, in part because they had nearly $100 million in deferred maintenance costs listed in that staff report. It's actually closer to 80, but moving the dollars around, it gets close to 100. At the same time, they did not mention a pipeline that broke that was a $10 million repair we heard at some point, 16. So that's where the $100 million you're hearing from the city. I also want to point out that in 2021, when they filed this groundwater adjudication, they did not need to file a groundwater adjudication to deal with the sustainable yield. If they truly believed it was wrong, they can take a validation action, challenge it. They did not need to sue the United States Navy. They did not need to sue the small farmers out there. You're going to hear from a small farmer in a little bit who will tell you that she has tried to find an attorney, cannot afford one, and cannot find one to represent her in this. But because of the way adjudications are written, if she does not participate, she will get no water right in that adjudication because she can't be represented. And that is the biggest problems with these adjudications. If you believe that the sustainable yield number is incorrect, let's take care of it quickly, as fast as possible. That's what validation actions are for. If they want to change some of the process in how you do a validation action, let's do so. But let's also be clear right now. You heard from Searles Valley Mineral. They have a validation action filed against the GSA. They are not prosecuting it because they want to move forward in an adjudication process where they're suing every single person in the valley. Small de minimis well owners, there's 800 of them out there. That's our estimate. It's a little hard to determine. They will have no representation in this case. Nobody's there to protect them. The small farmers, nobody's there to protect them. We have what amounts to 3 well-financed, one being financed with public agency dollars, entities attacking small farmers and de minimis well users. That's what this is about. And I want to point out one other thing. The report that you heard earlier, this sustainable report, the report they provided us in September said the sustainable yield was somewhere between 14 and 16. Today, they say it's between 14 and 11. Now, I used to be a lot younger, but now I'm not. And I can tell you in my lifetime, over 50 years, there have been 12 studies of that basin, not including the ARSA study. Every one of them has come back with sustainable yields less than 10,000 acre feet. Substantially less than 10. 9 is about the highest. Most of them are closer to 7,650. And this, I'll leave with this also. The concept that it's hydrologically impossible for 7,650 to be what we found in our first model and our revised model, that's not true. In fact, what's happened between 2020 when we developed the model and 2025 is the model has gotten more finite, the error rate has shrunk, and that's where we're at. And I should ask just one final thing. When we entered into the GSA and into the GSP, we developed the model, we had one goal. What is the right number? We didn't have to justify litigation costs. We didn't have to justify millions of dollars spent to support a decision that was made with no scientific evidence. They've admitted they had no scientific evidence in the summer of 21 when they filed the adjudication. We were after one thing. What is the right number so that we can build a sustainability plan? No public servant, and let's also be clear, they're public servants on these GSAs. Somebody earlier said they're not elected officials. You cannot be on a GSA without being an elected official. GSAs are made up of elected bodies. Planning or water agencies are the ones that are on GSAs. So it's elected officials. Those elected officials will never select a sustainable yield number that is artificially low. They're always going to pick the highest because they don't want to be building projects. They don't want to tax their community. So the concept that the sustainable yield number is somehow going to be artificially low or unrealistically low is just not plausible. Beyond that, because there's the validation actions, and we at the GSA would have to prove our number in court supported by substantial evidence, it's very irrational to believe that a court wouldn't bounce any GSA and GSP that had an artificial number. It's just not realistic. So I think that sort of answers the general questions that we've heard so far. I do want to point out one final thing. The groundwater model at the GSA, it was developed by the Desert Research Institute, who was hired by the United States Navy in 2016 to consider that basin. That model has been looked at in 2016, 2020, and now 2025. And 7650 is the number we've come up with. There's validation action filed. If somebody would like to challenge that number in a validation action, we look forward to defending it because we are completely confident that we would win at a validation action or an adjudication. But the problem with an adjudication is tens of millions of dollars will be spent by that community, and people like Mrs. Quist, whose small farm out there, they won't be able to participate, nor will all of the small well owners. So.
Supervisor Peters, do you have a question?
I do have one more question real quick. I don't know if this would be more appropriate for county council or for CAO's office, but I know we recently hired some outside counsel to advise the county on water. How difficult was it to find an attorney to represent the county?
Supervisor Peters through the chair. It was not an easy task.
Thank you. I wanted to ask if our clerk would be able to put up a slide that was from Western Growers. Yeah, that's it. Thank you. And Mr. Hall, could you translate this to English and add a legalese for us?
Sure. So to begin with, Civil Code of Procedure, Section 836, that's one of the adjudication statutes. This says, it is a person's duty to appear in the action, that's the groundwater adjudication, if they claim an interest in the proceedings. That would be a water right. If you have a water right, you think you have one, you have to be in the proceedings. If you do not appear, then you have not fulfilled your duty, and you would have no water right claim or storage right claim in the adjudication. And the last of this, because it's an NREM, that's adjudications are against every property owner. So if you don't like a sustainable yield, what's going on is rather than suing the GSA that came up with the sustainable yield, we have people sidetracking that process and suing everybody in the basin. Now, why are they doing that? They're doing that because it'll delays the sustainability project. The Water District's same staff report that we talked about earlier from 2021 clearly says the reason they cannot go out and bond for the water purchase is because of the ambiguities created by the litigation they filed. That adjudication, if it moves forward, is probably going to take another 5 or 10 years before you get through the appeals process. During that time, the GSA will probably not be able to bond for the construction of the project, the pipeline. The Water District has paid $14 million so far, roughly, in fees that are staying in a bank account to purchase water. So we'll be able to purchase the water, but we won't be able to do the construction. And the GSP currently predicts, with no changes, 1 in 10 wells will go dry in that basin by 2030. Predicts 1 in 4 by 2040. Now, we've made some measures, so those numbers aren't going to be quite as bad. That was looking at 2020 with no changes. We've dropped pumping 6,000, 7,000 acre feet, so it's a little bit better. But as you're hearing, 1 in 10 wells in a decade if we did nothing. So delay is not really an option. And I think that's one of the reasons why we've lined up the first tranche of what'll be $200 million of federal funding for a pipeline. And I should say one other thing. We heard, why didn't you do a cost study for import water? 27 million Californians currently receive imported water. California City currently receives imported water. The comments that we've heard that this is going to triple and quadruple water rates out there, they're not supported by what's happening in the rest of the state. So.
Well, I just wanted to come back to this real quick. So, and you don't have to answer this, I mean, feel free to if you'd like, but we just heard from county council that it was extremely hard for us to find somebody to represent us as far as getting legal counsel for the county. And compared to small farmers out in the Indian Wells Valley, we're the 800-pound gorilla in the room.
Yeah.
Even if small farmers could afford that representation, is it likely that they're going to be able to find somebody that's willing to represent them?
I think you should ask Pat. She's had to try that, but that's in that valley. For us here in this GA, when this basin over here that we're setting in gets adjudicated, which is where it's headed if Sigma doesn't work, I'll be honest with you, an attorney looking at this as a business decision is going to see the county of Kern, which is not going to be paying as much as Bolt House, Diamond Farms, Grimway, all the other large farmers that are going to be investing in this. The county will not be investing as much. We are not, and a lot of the times it's great if you represent the county and you're outside counsel. This is not going to be one of those issues. So I'm sure part of what we experienced, I wasn't involved in that search, but I'm sure part of what you experienced was people going, if I represent the county in this, I'm going to be conflicted out and can't take one of the paydays. And that's something we should really be considering.
Thank you.
Thank you, Supervisor. Okay, who's next? Please come forward, state your name for the record, and good afternoon.
Good afternoon. My name is George Kroll. I'm the General Manager of the Indian Wells Valley Water District. I wanted to say that it's not often we agree with the GA, but we do agree on this. In our amendments, and we are asking you to oppose unless amendments, our amendments include exempting these small water users that Phil has rightly pointed out don't have the capability or the funding to stand in court. So part of our amendments we're asking you to support by opposing would take that burden off those people. Those are some of the amendments that we have. I'd also like to say I'm the architect of the cost study. If anyone has questions, I would like to say that I initiated that study. I asked the Groundwater Authority to please participate. We used all of their numbers that we could. They refused, flat out. I asked them before we did the study, while the study was going on, after the study was done, and I also am a member of the Policy Advisory Committee for the Groundwater Authority. And I want to add, I was told, hey, when we do these updates to the Groundwater Sustainability Plan, you'll be fully involved. You'll get to see the drafts. None of that happened. No meetings, no input. They simply stopped having those meetings. Even their own technical advisory committee complained at one of their own meetings that their technical advisory committee didn't get to see their updates. So to say that we support what's going on in the bill, one of the things we support is if you are doing a good job and you are being transparent and you are working with the community to move forward that number. If you're not, well, then that needs to be looked at. I want to thank you for your consideration to oppose unless amended.
Thanks for being here.
And any questions? Thank you.
Maybe, we'll let you know.
All right.
Hello, good afternoon, welcome.
Hi, I'm back. Just a couple of quick points, and then I'll step back. Thank you again. With regard to the
Madam
bonding
Chair,
issue.
can we give everybody a chance to speak first before we start having more people come up?
I think that's fair. Could you hold off, sir? Because this is now your second time. I'm so
Yes,
sorry.
I
Normally, we
absolutely,
would.
it
we
was
would-
just, I appreciate that, I'll step back. It was just a clarification to some comments from the previous,
I appreciate it.
the previous speaker.
Got it. I'm so sorry to do that, but that is generally fair.
I've done the same thing.
Thank you. Can I ask again, who's left to speak? Oh, very good. Okay.
Hi, I'm glad I'm not last. My name is Chris Ellis. I'm a private citizen from Ridgecrest, but been around for a little while. I'm also the Vice President and General Manager at COSO Operating Company. We're a, third largest geothermal company in the country. We operate out of Inyo County. I sit on the board of the directors of the Lone Pine Chamber of Commerce. I sit on the board of Indian Wells Valley Economic Development Corporation, and I'm the board chair at the Ridgecrest Regional Hospital. So I try to be fairly involved in the community.
When do you sleep?
Never. I want to thank Supervisor Peters and the board for getting together today, and Supervisor Peters for being transparent in this process. I must say, I thought we were here to talk about a couple of bills and support or not support, and this has turned into kind of a finger-pointing session, which I think is unfortunate. But I think it's important to understand how we got here. So I predating Supervisor Peters, I was quite involved with Supervisor Gleason and a big supporter of both. I think both wonderful gentlemen and have worked very hard for the community. So,
Indeed.
however, at some point over 10 years ago, we got to a point where, and I've heard the word transparency, and this is what I want to talk about, and how do we get here? And because we shouldn't be here. Where we should be is have already worked out a solution that worked for everybody, and maybe that's a naive and unrealistic. But what I heard over 10 years ago was there are no alternatives to this pipeline, and this was during a discussion about putting a replenishment fee on all the taxpayers. And by the way, I have several employees that live in the city of Ridgecrest as well, so we're affected. And I look at any action, and I'm sure all of you see these from time to time come through Planning Commission, et cetera, a NEPA process, let's say, and how many of those can make it through with no review of alternatives? And honestly, that's how we got here. And at the end of the day, things have been pushed through without as much public involvement. And because of the litigation, I think many things have gone behind closed doors, et cetera. And it's unfortunate. And again, I think everybody's worked very hard to try and get to a solution. I hear about dates, et cetera, and why things happened when they did. And at this point, I don't know that it really matters. What I would like to talk about are the two bills that are in question. And I think I've heard a lot of great comments on both sides. But at the end of the day, adjudication has been I'll call it the mediation process that's been out there and worked for a number of years. As was pointed out, it was contemplated as part of Sigma, and to try and go back and have revisionist history, regardless of what we're talking about, I think would be reckless at this stage. In addition to that, I think you've heard conflicting testimony today regarding what's actually happened relative to some of the decision making that's been done. And so we have another bill that suggests that a GA should be held to a higher standard of scrutiny than what currently is out there. And so in that regard, if we expect to have an efficient and effective public process, I'm urging you to vote against both of these, or take a position, you don't get to vote on these, obviously, but to take a position on behalf of Kern County, which I believe is the most important county in California, in terms of.
nation.
Yeah, fair enough, but in terms of production of, well, obviously, I'm a big oil and gas fan, but,
me too.
but ag is super important to what happens here. And so, I think we need to protect the processes that are out there and not do these stopgaps that potentially harm what we've been trying to accomplish. So I'm urging you to take a position against these two.
Thank you, sir.
All right, thank you for your time.
You were very civil too, by the way.
It's tough.
Yeah. Yeah, for all of us, trust me.
He's a very
You're not alone.
nice man, Chris Ellis. Good afternoon. On the subject of the bills, the topic of the legislation, I'm Madam Chair, members of the board, I'm Tracy Leach with Providence Consulting. Providence has many clients, colleagues, business partners who are very much opposed to these two bills unless amended. However, today my comments are in opposition from Kern Citizens for Energy. As most of you know, KCE was formed in 2014 to support our beloved oil industry, local production, advocate for same, and all the men and women who work in this industry. And that's why we exist. And today we are the largest coalition of its kind. We have thousands of members. We've had the privilege of filling these chambers, even this entire property, with the very great people of Kern County who love the oil industry and work in it and support it. So we feel the same way about growing our own food. So we're happy to support our friends and allies in agriculture today and ask you to oppose these bills unless amended. We are super proud to be from Kern County. As the chairwoman stated, we are the largest ag producing county in the country. We are also one of the largest oil producing counties in the country, and we're very proud of these industries. And what's harmful to agriculture, we are happy to speak up and support them. So we would ask you to oppose these bills unless amended. Thank you.
Okay, who's next? Thank you for your patience this afternoon. I'm learning so much.
I'm Pat Quist Farms.
Hi, Pat.
My family and I have 150 acres in Ridgecrest. We've been there for over 50 years. Hello, everybody that I know.
Wow.
One of the things that's very, very dear to my heart is the town and our farm, which is right outside the edge of town. And I've watched all these things happen for the last 40, 50 years. I've been a part of them. I've been on committees. I've led committees. I know some of these people back here. I've watched some of them grow up. I've hired probably 30, 40 kids, teenagers from our community over the years to work for us. So we feel like we've seriously contributed to this town. I'm going to say I support this because as much as these guys don't realize it, I could not find an attorney, not any way at all. I can't afford one because they're way out of our league. They don't even want our business. We're not big enough for them. So we fall into that slot, my family and I, where we're too big for some people and too small for the others. And I want you guys to understand, it's very, very important to us. We've done every single thing that we could possibly do to farm in the desert. Everything. I mean, we've supported solar energy before anybody did. We supported drip irrigation before anybody did. We've been there. And if there was an improvement to make, we made it. And we proved that it could be done. In fact, the Farm Service Agency and the NRCS call us a jewel of the desert, of that community, because we've proven how well it can work. So we grow food, We don't grow trees. I think I have one shade tree on 150 acres. One. So, if you have questions, I'll answer them if I can. I do not understand, I have to be honest, I do not understand opposition to things that would be good for the community. I don't see why you would take ratepayer money and spend it on attorneys. Not that I don't like attorneys, I think they do a good job.
They're pretty bad.
Pretty much,
Just kidding.
except for the
I'm
ones that
totally-
won't.
I'm an attorney, that's why I said that. I'm
Yeah,
joking.
well, they don't want to work for me, but that's okay. I don't understand why you would take ratepayer money and not build a pipeline. We have one water source, one in that valley. And I will guarantee you, I am right there when my husband and I use our pump rig and pull our well up, our pipes up out of the ground. I can tell you that water is going down. Every single year we have to work on one of the wells. Every year we pull the pipes up because our pumps hang on the bottom of the pipe. And I can see where that water table is going down. Okay? Every single year it goes down about a foot. All right? So anybody have questions, please ask them. I'm out there every single day. I watch everything that's going on. I have attended many, many meetings, just about all of them. I even went to many, many meetings and sat with Dr. Sainamon, Pierre, David's dad. A fascinating man, by the way. Okay, so I date back. I'm 81, almost 82 years old. I've been doing this for a long time. So if you have questions.
Okay, thank you, ma'am. We may call you back up, depending on how the conversation goes. Okay, who's next? Good afternoon.
Madam Chair, thank you for the time. I know you saw my face up here, but taking off my Farm Bureau hat, my name is Alex Dominguez. I'm a local water attorney here in Kern County working for Klein Dinatale Goldner. Well, we represent a number of groundwater sustainability agencies throughout the state of California. Here I'm just speaking from my knowledge and offering that up to the board. I must say I'm thankful for the crash course in issues affecting the Indian Wells Valley, but I think what a lot of the commenters have shown me today is that what these two pieces of legislation are trying to do is really address a particular issue with a particular GSA. And I think we all know the unintended consequences that likely come up as a result of one-size-fits-all legislation. And unfortunately, I think that's what we are faced here today. Outside of the comments that I would consider in the group of very particular to what's happening in the Indian Wells Valley, excuse me, I think the second group of comments are folks who are just concerned with the adjudication process generally. You heard from the general counsel for the wonderful company, Melissa Frank, who said the same things. Hey, the adjudication process, it isn't a fun process. And like some of the other attorneys out there, as an attorney, a water attorney, I can say that they're not fun to be in. So I agree and I sympathize with the members of the community who do have concerns regarding the affordability of participating in adjudication. Unfortunately, I think these two bills will actually result in more litigation, not less. As you've heard time and time again from the proponents of these two bills, if supporters want to challenge the sustainable yield, the safe yield that is set forth within a GSP, they can just file a validation action. Well, Indian Wells is the perfect example of that. Already what they've seen is the validation action and an adjudication. So if that's going to be the new model that we create up and down the state, not only is the GSA going to have to increase its fees to its landowners to afford costs for the adjudication, but it's also going to have to increase its fees and potentially hire additional counsel for the validation action proceedings. So Again, I would just say that I hope that the Board of Supervisors does, in fact, not support these bills. Thank you.
Okay. Mr. Turnipseed, it's nice to see you. Good afternoon.
Madam Chair, members of the board, as somebody who's been returned from college almost 50 years ago next month, this is very, it's just, when you went through this whole thing of Sigma, went through the whole thing, and really the thing that I got from all my research, my phone started ringing Friday afternoon at 3 o'clock and say, what are the Board of Supervisors doing in Kern County? Why are they hearing this and why? I said, about what? So I crashed on over the weekend about this. But one thing that seems evident, there have been 86 successful plans adopted, and only 5 went to adjudication. That's a 94% success rate. I've never seen anything else in the state of California that's ever been 94% successful, at least from the legal point of view with adjudication. So, complicating and just throwing up a suit, we're not for this, but I can tell all our partners in Sacramento, whether it's the Farm Bureau, whether it's the Cal Chamber, whether it's Western Growers, whether it's the whole ag community, they are not for this. So Kern Tax is not for this because we have partners. And after listening to this, this is more like a backroom brawl, like the Hatfields and the McCoys in a neighborhood that could have, and the outcome of this legislation would affect the whole state of California. And we don't think that's appropriate at all because it is an argument about due process. Thank you.
Thank you, Mike. Good afternoon and welcome.
Madam Chair, members, thank you. First of all,
who are you?
I'm the 32nd Assembly member.
Oh, yeah, that guy. Congratulations, by the way, Mr. Ellis. And I think it's stunning that you're here on this issue. I think it's brilliant. All politics is local, as you know. And so I'm happy that you're here. You're an incredibly respected voice, and I'm honored that you would take the time to be here. Given who you are, your credibility, I trust that your perspective is one of integrity.
Madam Chair, thank you. So I did, as Mr. Turnipseed, I got a crash course this weekend too. And last week I actually talked to the author, Pappin, in San Francisco, in the assembly floor. I won't say what was discussed, but after I looked at the bill last week and then this week, I'm going to make one statement. We need fair, transparent, science-driven water policy, but not at the cost of due process. Thank you.
You waited a long time for that statement, Mr. Ellis. That's powerful.
Sometimes less is more.
Other politicians could take lessons from you, myself included, myself first. Okay, any other speakers? I know we have another speaker that's going to come forward from the district in a moment, but anyone else want to weigh in? Now's the time because the decision's going to be made here momentarily. Oh, okay. Apparently our former supervisor, Mick Gleason, prepared a letter. I'm going to distribute it. Okay, it appears, I haven't read the letter, it appears Mick Gleason, former supervisor Mick Gleason is in favor of these bills, urging a support vote for the bills. I did not get a chance to read the letter, unfortunately, just receiving it now. Anyone else in the crowd that would like to come forward? Okay, sir, would you please, if you wanted to come back and clarify, and you're going to be our last public speaker.
Once again, David St. Amand, this year's president of the Indian Wells Valley Water District. Given the lateness of the hour and wanting to be respectful of the Board of Supervisors' time, I'm not going to address what could only be described as some astonishing misstatements about the Water District. If anyone on the Board of Supervisors is interested to know about any of the accusations or claims that have been made about us, please just contact me. But I will say, since I don't enjoy brawling and I don't want to get in a cat fight, that how this discussion has gone really demonstrates and proves my earlier point that this is the reason this has been brought before the Board of Supervisors is to increase the chance of a law coming into effect that can be used against a very small geographic location in the state of California. But that law will apply everywhere in the state. And again, I urge you to either vote to oppose supporting or oppose unless amended. And thank you so much.
Thank you, sir. Okay, we're going to close the public portion. I want to sincerely thank you from the bottom of my heart, all of you, every single one of you from this community who really comprise the community. As an outsider, I felt incredibly educated, informed, and brought up to speed on these real conflicts that I actually do have every faith that this community is going to come together and work through once we get past some of these difficult stages. But I really want to thank you. I mean that, taking the time to come here. And this has been a bit of a crash course for me, too. But your input has been absolutely vital and critical. I'm so grateful to you. I don't see anybody plugged in, but I'm going to go to you, Supervisor Peters, since this was originally brought forward by you. And your thoughts, and how do you want to proceed?
Sure, thank you, Madam Chair. I also appreciate everybody coming down and weighing in on this. I would say that my concerns that I brought up with several people that I've discussed this with weren't really addressed today. We heard from Pat Quist, who's a small farmer in the community that this impacts, heard from other community members why this is beneficial. Everybody that came and spoke against it, by and large, while there are a great number of people that I respect in it, we heard from farmers, we heard from big farms, and we heard from people that have a financial interest in those big farms. We heard from a lot of lawyers, and yeah, if I was a lawyer, I think I would be asking us to oppose this as well. That's like asking a barber if we should oppose this, or excuse me, asking an attorney if we should oppose this is like asking a barber if you should get a haircut. There's no reason that they wouldn't say yes to it. We heard from a gentleman from Bolthouse saying everything is working, and if it ain't broke, don't fix it. And I would say I agree from his point of view that everything's working, but who's it working for? I'm sure it's working for people that are delaying implementation of sustainability measures to continue mining water from our basins, but it's not working for small farmers and for community members that are at risk of losing their wells and their livelihoods for not implementing these measures. It's not working for people that are paying millions of dollars in protracted legal fees to fight these delay tactics. We heard from somebody that leaving the legislation as it is would make the GSAs the king out there. Well, I would rather have a GSA that's made of local individuals that are actually impacted by this be the king over it than making the king and a judge that's from out of the county and the parties that have the financial ability to litigate this for years in front of him. Again, as I said, there are many speakers today, and among some of the opposition were a lot of people that I respect their judgment and their integrity, but I don't see how not moving forward with this would in any way benefit my community. And as I said when I first started, that's the ultimate question. It begins and ends with, is this beneficial for members of my community? And I believe it is. So I'll make a motion that we support.
Thank you, thank you, Supervisor Peters. Supervisor Couch.
I'm going to attempt to be as succinct as Assemblymember Ellis, but I'm probably not going to succeed.
No, you won't.
I want to get to the bottom of one thing before I make a comment, and that is, are the representatives from the city of Ridgecrest still here? Can you come to the podium for just a moment? I just want to ask you a couple of questions. All of us? Sorry? And as you're coming down, I too had a crash course in maybe a refresher course on Sigma and then a crash course on the Indian Wells Valley Groundwater Authority and the issues there, and I'm sure that I don't understand them all. But I also saw articles in the paper from a man that I very much respect, Scott O'Neill, about the support from the city of Ridgecrest. Can you clear up, was there actually a vote taken by the city of Ridgecrest to support these bills? Well, let's stop there.
Sure, yeah, no, you're fine. So Supervisor Couch, I knew I liked you for some reason. So thanks for bringing that up. There was not a Brown Act violation. And to even say that there was a Brown Act violation, it implies a lack of, look, I know you say he's your friend and he is a respected member of our community, but it implies lack of knowledge of the Brown Act. There is stuff that goes on in closed session, as you guys know, all the time that involves legal strategy.
But is there an official position of the city of Ridgecrest to support the bills?
Yeah, the city of Ridgecrest supports these bills.
And that was determined in closed session?
Correct, sir.
Okay, I'm not sure. I'll just make this comment because I'm not a legal expert either, but I'm not sure that that's.
We could always ask any
sure.
lawyer to come up here, but no, I don't. We have a legal strategy, so that's what we followed.
All right, I appreciate you coming down and answering that question.
Yeah.
I just wanted to clear that up because I read that and I thought you all need to explain that.
Well, no, I'm glad you did ask it because it was written and put in the newspaper. It was a political strategy to take a swipe at a council member. I understand that, and I'm not immune to it. Neither are the rest of the council members, and neither are you guys. You understand how it goes.
Absolutely. Thank you. I appreciate it.
You better believe I'm not immune.
I know. I read those articles.
Do any of you want to weigh in on that or respond to that? I want to give you a chance if you want to.
I think as in all elected bodies, we have a legal strategy. And sometimes it's not appropriate to discuss that legal strategy, obviously, because of the Brown Act. So.
Well, it's probably never appropriate to discuss your legal strategy.
Correct. And just because it's written in the paper doesn't always mean it's true.
But, well, let me be more direct. Was there ever an item on a public agenda, an open agenda, where the council was able to vote affirmatively to support either of these bills?
This specific item, no.
Okay.
But we do have on our agenda the Groundwater Authority information every meeting.
So a report of some kind from the.
Correct.
From the GA? Okay. Thank you for your help, gentlemen. I appreciate it. I'd like these, I'm going to put these comments on the record, and Kathy, I have it printed out for you, so you don't have to worry about recording it. I've thought a lot about this, and I know it's a difficult subject. I think this is one of those days, one of those times where, and I do appreciate all of you, the way you conducted yourselves today. The board members, the people that are here, it's one of those days where I think people of goodwill may disagree. This is my statement. The sustainable yield under Sigma is a dynamic figure. It's reviewed and refined every 5 years as new data like project outcomes and climate effects become available. In my view, the GSPs are tools to manage groundwater sustainability, not for determining water rights. That's the role of the court in an adjudication. Given this evolving number, too much weight in an adjudication, in an adjudication risks lawsuits with every GSP update. I think that's what some of the people who said it might invite more legal actions meant. Over time, the sustainable yield and the safe yield should align, and we should allow space for that to happen without forcing premature legal battles, which I believe, after reading them, AB 1413 and AB 1466 have the potential to do. So I'm not going to second the motion or vote in favor of the motion because of that. Thank you.
Understood. Thank you, Supervisor Couch. Thank you for stating your position clearly and openly. Supervisor Peters is set now. Okay, Supervisor Peters.
Thank you. Just to bounce off of a question that was asked of the city of Ridgecrest, we also had a discussion regarding these bills in closed session. It was not put on the agenda by me. The request was not made by me. I'm not sure how that came to be part of our closed session discussion, but somebody had to recommend it, somebody had to put it on there. I've asked county staff 3 times who that person was and how that was added to our agenda, and have yet to receive a response. So I would like to publicly ask for that information now.
Supervisor Peters, through the chair, these are closed session items, so I know that county council has probably a prepared statement. Yeah, Supervisor Peters, through the chair. This is a difficult question to answer in open session because it is a closed session item. I have full faith that we complied with the Brown Act. We did not specifically put these matters on an agenda. It was under updates for particular pending legislation, and we wanted to discuss the impacts these bills could have on that legislation. Counsel for Indian Wells Groundwater Authority was not available on that date. You indicated you did not want to discuss it on that date, so at the beginning of closed session, I said we were pulling it. And then I would, so as not to violate the Brown Act, I don't think I can go into any further detail than that. I did also respond to your email and advised you as to how those were placed on the agenda, and that was the most that I could tell you at the time. I don't have any further information.
Okay, well, just to clarify, that still doesn't tell us who placed that on the agenda, who asked for that. It's not normal or routine in my experience in the entire time I've been with the county to review any legislative matters like that. So I'll continue to look into it. Thank you.
Supervisor Peters, I'm the chair, and I want you to know I did not ask that matter to be placed. I do think I need to tell the public that. Moving forward, I see Chris Parlier has plugged in, and then or punched in rather, and then we'll hear from Jeff Flores.
Thank you, Madam Chair. Well, first of all, I just want to thank Supervisor Peters for him fighting for his constituents and for Indian Wells and the city of Ridgecrest. Our areas have so much overlap because our districts border each other from almost the city of Bakersfield as we go east. And we have so many cross-district issues that we walk in lockstep with, and rightfully so. But fortunately or unfortunately, my area also carries into the valley and goes all the way into Cuyama and goes all the way south into Tejon and Tejon Ranch and all the farmland that is south of Bakersfield, and arguably has, maybe next to Supervisor Couch's area, the most farmland of any district in the county. Now, when it comes to this legislation, I heard from Alex Dominguez, attorney, saying, you know, one size fits all. And I agree with that statement in the fact that it doesn't fit the valley or the valley floor. So essentially, you're using a legislative hammer when you really need a legislative scalpel to go with a local issue. And I don't know if there's an opportunity to do an in-district bill to help take care of the problem in Indian Wells and the Ridgecrest communities. And obviously, it needs to be fixed. I mean, this is a mess, and it probably does require legislation. But I think that is finite legislation that deals with this specific issue without blowing up the whole process of Sigma, GSPs, and the GSAs. And I'm not even going to get into the litigation or the judicial part of it, but that is a factor also. But again, my point is that I think it should be specific to that region, and I cannot support a support position.
Thank you, Supervisor Parlier. Supervisor Jeff Flores.
Thank you, Madam Chair, for guiding us through this special PM meeting on water. Thank you for everyone's comments. Thank you for the public for coming out, and thank you for those eloquent words, Supervisor Parley, which partially capture my sentiment. You know, it's been a long haul with Sigma, and philosophically, I never even supported it from the beginning. I think that the market is the best arbiter of water and sustainability, and it's everyone's market interest and farming interest to sustainably use that water to the best of their ability for the future of their farms, for the future of their districts, for the future of their constituents. But that train has left the station. So, you know, I understand that this group in the Indian Wells Groundwater Authority came together. I understand it's been a long process. I understand my colleagues' service to that and looking out for his constituents and looking out for water interests and trying to make the best of it. It's been difficult. A lot of variables, a lot of interest. But when people pursue, you know, an adjudication was fundamentally it was embedded in that genesis of Sigma. People have the right to adjudication. People have used that right in that groundwater authority in that basin. It's in the courts in Orange County. And it's frustrating for some because they want to see closure. They want to get their plans submitted and approved. But it's also a life raft for others because they fundamentally have a right to pursue those rights through adjudication. And also, I think this bill presupposes perfect numbers. It presupposes that there's not going to be mistakes. It presupposes that the process is going to be flawless. So hypothetically, what happens when those numbers aren't perfect? What happens when you do need to press them in a more comprehensive venue in adjudication, more so than the validated action, which says go back and redo it? In some cases, that may not be good enough. And so, again, I understand the locality of the problem. It's very complicated, but you're bringing a prospective solution to this complicated issue in a very distinct basin, and you're applying it to not only the west side and all these other basins with unique characteristics and unique variables, different water tables, what have you, but also statewide. And that variation is even more complex. And, you know, ag is important. Ag is spoken out, and I have to look at the big picture. People have spoken on both sides, and I value everyone's opinion and everyone's interest. But I have to look out from a global perspective. What's in the benefit of the industry, of our state, of the multitude of water agencies and water players and farms, and this localized solution is not the best fix for what ails us or challenges us on our side. Not to mention, there's not even unanimity in that very own basin because you've got people that have splintered off. You've got opposition within that same groundwater authority, as well as the wider community. I think that due process is fundamental. It's important. And as they pursue their rights in court and their rights through legislation, they have the right to pursue legislation. I have to look out for the larger rights of others, and they want to protect their rights through existing channels of adjudication, which is more robust, more comprehensive, and I don't want to take that and diminish their rights in the process. So that's where I'm coming from. And I've been through adjudication in AVEC. It's costly, it's lengthy, but that is the best venue, unfortunately, to press the rights to the fullest degree. I know it's time consuming, and I understand that because I used to work for Rio Tinto, and it was tough. But that is the ultimate place to present and assert rights, and sometimes that's necessary. But people alluded to the number of plans that have been approved statewide. The majority have. There's a small minority that haven't, and so I think that prognosis is a good one. So thank you.
Supervisor Flores, I assume that is not a second to the motion?
Oh, yeah, correct. It's not a second.
Okay. So from what I can see, as chair, I see 3 supervisors up here that cannot support this at this time. I hear openness to future solutions as we are, have been very informed and brought up to speed on what appears to be quite dynamic. So where we are, procedurally is we have a motion and we do not have a second. And you can see from the layout of the comments that there does not appear to be majority support on this board for the motion. Supervisor Flores, is that from now or?
Correct, yeah, and that's not to take away from my colleague's intent to press for his constituency and find resolution and the hard work that's been involved. They're pressing every available recourse, and one of those recourses is legislative action, and I get that. But I'm looking at it from a different lens, from a more global lens, and I don't think it's the best for other interests in the valley and statewide.
Thank you, Supervisor Flores. Supervisor Peters.
Thank you. I just want to say I appreciate, again, everybody coming down here and sharing their viewpoints. I appreciate my colleagues giving this some thoughtful consideration. This is a difficult issue, certainly. I still think that there may be some fundamental misunderstanding about exactly what this does, and but that's neither here nor there. I'll just say, as somebody that's been going through this process for a long time, I definitely see the value in this and the way it would help our communities. And I know that there's not adjudications happening in your districts right now. I don't hold it against you that you don't support this, but I also hope you won't hold it against me when I say I told you so when those adjudications happen.
Supervisor Peters, thank you. Okay, seeing, do we have to make an official proclamation that the motion fails for a second, or is it obvious?
Madam Chair, the record will reflect that the motion died due to lack of second.
Okay, looks like we've come to the end of our meeting. I sincerely appreciate you all so much.
Item 3.
Oh my gosh, we're not done yet. Forgive me. Item number 3 is up, and it's also CAO, I presume. It's also under the CAO's office, so in light of time, I'll go right to you.
Madam Chair, I'm going to have Assistant CEO Elsa Martinez introduce this item, and I believe County Council has some comments as well.
Okay.
Madam Chair, can I jump in there
Please.
real quick? I would like to just make a motion that we table this until our next meeting.
Sure, second.
We have a second on that. We have a motion of tabling the second. I'm sorry, Peters, could you say what it is that we're tabling?
Sure. I propose that we table item number 3, proposed agreement with Indian Wells Valley to recognize the authorization contained in section 1304, item 431 of Public Law 118-272.
Thank you, Supervisor. We have a motion to table, and we have a second from Supervisor Flores. Can we?
I have a question.
No, oh, I'm sorry, Supervisor Couch.
What is, I'm sure, this is I forgot. Tabling means bring it back to at our next meeting, or just bring it back at a later date? What is, so, tomorrow? Or a week from
Supervisor
tomorrow,
Couch, the chair, our next meeting is next Tuesday, the
week from tomorrow.
13th, so we'd be happy to move this item to May 13th, if that's the supervisor's request.
Thank you.
Okay, got it. So maybe continue is the word we should use.
Yes.
Is that
but you-
okay?
Yes,
Yes,
but you
thank
should call for public comment.
I see. Is there any public comment? You better not. Just kidding. Is there any public comment on continuing this matter to next Tuesday? We have a thorough discussion at that time. Okay, we'll close the public hearing. We have a motion for a continuance. Do we have a second?
Second.
A second to continue this matter to next Tuesday, the May 13th at 2 p.m. Anything else, Kathy?
No.
Okay, thank you. We have a motion
I'm
and a
sorry.
second.
Yep.
Please cast your votes.
I'm sorry, Supervisor Perez.
I missed it.
Let's start over with resetting the vote. Okay. Supervisors, please cast your votes. Thank you. Now everyone has voted. The vote is all ayes.
Thank you very much. Jeff, motion to adjourn?
Yeah, motion adjourned.
Thank you, Supervisor Flores. We are adjourned.